Welcome back to Krishna's Lawrials. Last class లో క్రిమినల్ లాస్ ఫస్ట్ హాఫ్ చూసాము 4 steps, that is intention, preparation and attempt and commission of crime. So ఇది కంప్లీట్ చేసిన తర్వాత we have seen a brief distinction between intention and motivation. So now we are starting with uh, what are the new laws that is in criminal law. What we had before the changes in 2024, you know that we got new criminal laws because we have replaced old criminal laws with the new ones with Indian names. So here we are seeing what are criminal laws, in a sense, how many kinds of criminal laws we have and what are they. So coming to criminal laws deals mostly with two kinds of laws. That is one, ఒకటేమో సబ్స్టాంటివ్ ఉంటుంది, ఒకటేమో ప్రొసీజర్ ఉంటుంది. సబ్స్టాంటివ్ అంటే దీంట్లో మనకు అఫెన్స్ ఏంది, ఆ క్రైమ్ ఏంది, దాని డెఫినేషన్ ఏంది, దానికి మనకి ఎంత పనిష్మెంట్ ఇస్తారు అండ్ ఆల్ స్టఫ్ దే హ్యావ్ మెన్షన్ దేర్. అండ్ వెరాస్ కమింగ్ టు ప్రొసీజరల్ లాస్, they the procedural laws talk about the process how we'll take it further. So how you will file the plaint, how will, then how the advocate will reply it, and what will be the closing of evidence, how the cross examination works, how judgment comes in, and all stuff is written in procedural laws. So IPC is the substantial law, as it defines several offences and also lay down the punishment for such offences. అంటే ఐపీసీ ఏమి సబ్స్టెన్షియల్ లో ఆడేమో మనకు పనిష్మెంట్స్ డెఫినేషన్ కూడా ఇచ్చున్నారు. ఇంకా ఆ పనిష్మెంట్స్కి ఆ క్రైమ్కి ఉన్న డెఫినేషన్ ఇచ్చారు కదా, దానికి పనిష్మెంట్స్ కూడా దాంతోనే ఇచ్చారు. సో కానీ అదే సిఆర్పిసి, మన సిఆర్పిసి ఇంకా ఇండియన్ ఎవిడెన్స్ ఏమో ప్రొసీజరల్ లాస్ అంటే ఆడవాళ్ళు ఏం చెప్పారు, హౌ మనం అంటే ఎలా మనము దాన్ని డీల్ చేస్తాం, ఆ పర్టికులర్ క్రైమ్ని ఎలా ఇన్వెస్టిగేట్ చేయాలి, ఆ క్రైమ్ని, మెథడ్స్ ఆఫ్ కండక్టింగ్ ట్రయల్, ఇంకా ప్రొవిజన్స్ ఫర్ అపీల్ ఎక్సెట్రా. అంటే మనం ఎలా ఇన్వెస్టిగేట్ చెయ్యాలా, ఎలా ఎలా అపీల్ చేయాలా, ఇంకా అదర్ ప్రాసెస్ గురించి మాట్లాడుతుంది సిఆర్పిసి అండ్ ఇండియన్ ఎవిడెన్స్ యాక్ట్. సో ఇప్పుడు మనకు 2024లో కొత్త యాక్ట్స్ రీప్లేస్ అయ్యాయి మన పాత క్రిమినల్ లాస్తో. సో ఇన్ ప్లేస్ ఆఫ్ ఐపీసీ అంటే అన్ని ప్రొవిజన్స్ సేమ్ ఉన్నాయి, బట్ వీ హ్యావ్ డిడ్ సమ్ మోడిఫికేషన్స్. సో హియర్ ఐపీసీ అంటే ఐపీసీ బదులు వి గాట్ పిఎన్ఎస్ఏ, దట్ ఈస్ భారతీయ న్యాయ సంహిత. Then we had Bharatiya Nagrik Suraksha Sanhita, that is PSSA. Then that is replacing the CRPC. Now Indian Evidence Act is Bharatiya Saksha Adhiniyam. So coming to these three laws which came into effect on July 1st, 2024. So we'll see what was the origin, why it came into effect and all. So ఏంటంటే ఇది మన ఇండియా న్యూ ఎరాలో వచ్చింది. ఎందుకంటే యూజువలీ పాత లాస్ బ్రిటిష్ కాలం నుండి ఉన్న లాస్ నుండి వి అడాప్టెడ్ ఇట్. సో నౌ ఆర్ parliament said that now we are in a new era, and our Indian culture and the British culture differs. So we need to make laws as per our convenience. So we got this change, and we even renamed those laws in Indian language, like Bharatiya Nyaya Sanhita and all stuff. So the new era has dawned, and India has taken great steps towards evolution in the field of law with introduction to the new criminal laws. This initiative was originated when this idea came in was this 2020, when the Committee for Reforms in Criminal Laws, so this is CRCL, was established. So 2020 law CRCL was established, and then chairman was Dr. Ranbir Singh, Professor Dr. Ranbir Singh, and the transformative bill named as BNS, BSA and BNSS. This was bill named as, and this bill has promised to bring rebirth and replacing this outstanding laws. అంటే ఏమంటుంది ఈ బిల్ మనం ఎందుకు ఇంట్రొడ్యూస్ చేసామంటే మేము ఇంట్రొడ్యూస్ చేసాము దాట్ మన ఇండియన్ లాస్ని రీబర్త్ అవుతుంది, ఇంకా మనము మన అవుట్డేటెడ్ లాస్ని రీప్లేస్ చేస్తున్నాం. And erstwhile statutes with new legal frameworks that are specifically designed for the need of 21st century India. మన 21st century India అంటే మన ప్రజెంట్ ఇండియాకి ఏమేమి నీడ్స్ ఉన్నాయి దాని ప్రకారమే మనం దీన్ని డిజైన్ చేసాము, కొత్తగా రీప్లేస్ చేయొచ్చు మనం. So this new law, that is Bharatiya Nyaya Sanhita of 2023, is an endeavor to redefine and redirected the code and has replaced the IPC లో ఉన్న 20 చాప్టర్స్ 358 సెక్షన్స్ ని రీప్లేస్ చేసేసింది. అండ్ నౌ ద భారతీయ నాగరిక సురక్ష aims to redefine the criminal procedures. So the criminal procedures ని redefine చేసేసి it have said that by setting timelines for investigation, it intended to ensure that the justice is more accessible and responsible to the need of people. So here in Bharatiya Nagrik Suraksha, what they said that they have established the procedure where they said that investigation should be done as early as possible. In Bharatiya Saksha Adhiniyam, that is our Indian evidence, they have replaced the Indian evidence and it had an alteration to the structure of Indian Evidence Act. So on July 21st, 2024, these three acts came in force. Now we are seeing what are the very important sections which you should know under Bharatiya Nyaya Sanhita. So under chapter 20, section 358, they have okay. So this section talks about the assault or the criminal force which has grave provocation. So in BNS 358 talks about the assault or a criminal force on a grave provocation. It means if someone provokes you in a grave manner, in a sense he is provoking you to the extent that you assault that person or use a criminal force. 358 talks about that. Coming to section 20 Act of Child under 7 years age is talking chapter 20 mein, section 20 is talking about the act of child who is under 7 years old. Whereas coming to section 22, it is talking about act of a person of unsound mind. What if there is an act done by unsound mind? Section 61 talks about the criminal conspiracy. Section 63 talks about rape. Section 70 talks about gang rape. Section 80 talks about dowry debt. Section 100 talks about culpable homicide. Section 101 talks about murder. 111 talks about organized crimes. Organized crimes in a sense, something which are already pre-planned. And 113 talks about terrorist act. 114 talks about hurt, like if you'll hurt someone, not the grievous hurt, the minor hurts. Whereas coming to 116, it talks about the grievous hurts. 130 talks about assault. 137 talks about kidnapping. 138 talks about abduction. 270 talks about public nuisance. 303 talks about theft. And 308 talks about robbery. 304 talks about snatching. 309 talks about robbery. And so correction, section 309 talks about attempt to commit suicide, whereas 310 talks about dakati, 318 talks about cheating, and 324 talks about mischief, 336 talks about forgery, and 356 talks about defamation. Now coming to what is Indian Penal Code and what are the provisions written under this. So IPC is in substantive law. We said that a substantive law, in a sense, the law which consists of definitions of crime, what are the punishable, what is the punishable, what punishment is applicable for that particular crime, and so on. So here we have a basic difference that in substantive law we'll get to know what is the crime and what will be the punishment. Whereas coming to the procedural law, we'll see how we can approach the court, what will be the process of investigation, and how we will approach the court. So here it is consisting, IPC is consisting of 511 sections which deals with specific offense and the corresponding punishments for those offenses. It covers a vast range of offenses. In IPC we cover many offenses, of which some are cognizable and non-cognizable. You know, cognizable offenses and non-cognizable offenses. Some were cognizable offenses, somewhere where you can be arrested without any warrant, you'll not get any bail. And whereas coming to non-cognizable offenses, where you can only be arrested with a warrant and you can even get a bail. So cognizable means a police can arrest without any warrant, whereas a non-cognizable the police officer cannot arrest you without the warrant. IPC includes punishment for the offenses against the state, offenses affecting the society. In a sense, IPC includes all the offenses which are against the state, against the society, and offenses which are affecting the human body, property, reputation, etc. ఇన్ షార్ట్ ఏం చెప్తున్నారంటే ఐపీసీలు ఇట్స్ సబ్స్టెంటివ్ లా, దాంట్లో 511 సెక్షన్స్ ఉన్నాయి. ఐపీసీ అన్ని ఒఫెన్సెస్ డెఫినేషన్, అన్ని టైప్స్ ఆఫ్ ఒఫెన్సెస్ని కవర్ చేస్తుంది. ఇంకా ఒఫెన్సెస్లో కూడా మనకు 2 టైప్స్ ఉన్నాయి, ఏంది కాగ్నిజబుల్ ఒఫెన్స్ అండ్ నాన్ కాగ్నిజబుల్ ఒఫెన్స్. కాగ్నిజబుల్ ఒఫెన్స్ అంటే ఇప్పుడు మనం ఏదైనా తప్పు పని చేసాము, అది కాగ్నిజబుల్ ఒఫెన్స్ కింద వస్తే మనకు వితౌట్ వారెంట్ అరెస్ట్ చేయొచ్చు. వేర్ నాన్ కాగ్నిజబుల్ ఒఫెన్స్లో మనకు విత్ వారెంట్ ఉంటేనే అరెస్ట్ చేయగలరు, లేకపోతే చేయలేరు. ఇంకా ఈడ పెనల్ కోడ్ అంటే ఐపీసీలో ఎలాంటి ఒఫెన్సెస్ ఉంటాయంటే, ద ఒఫెన్సెస్ విచ్ ఆర్ అగేన్స్ట్ టు స్టేట్, అగేన్స్ట్ టు సొసైటీ, ఒఫెన్సెస్ ఎఫెక్టింగ్ హ్యూమన్ బాడీ, ప్రాపర్టీ, ఇంకా రెప్యుటేషన్. అంటే ఒక మనిషి ని ఎఫెక్ట్ అయ్యేది, లేకపోతే ఆ మనిషి ప్రాపర్టీని ఎఫెక్ట్ అయ్యేది, లేకపోతే ఆ మనిషి రెప్యుటేషన్ని ఎఫెక్ట్ అయ్యే ఒఫెన్సెస్ ఏమో ఐపీసీలో ఉంటాయి. ఇట్ హ్యాస్ ఆల్సో కోడిఫైడ్ ద సోషల్ ఒఫెన్సెస్ లైక్ పబ్లిక్ ఈక్వాలిటీ, ఎలక్షన్, ఒఫెన్సెస్ అగేన్స్ట్ పబ్లిక్ జస్టిస్, రిలీజియన్ ఎక్సెట్రా. ఇలాంటివి కూడా దాంట్లో ఇంక్లూడ్ అయి ఉన్నాయి ఐపీసీలో. ఫర్ ఎగ్జాంపుల్, సెక్షన్ 141 describes what is unlawful assembly, whereas 143 describes the punishment for unlawful assembly. You know, right, what is unlawful assembly? మన కోవిడ్ టైంలో కూడా అది మనం పెట్టారు 141, where more than 4 people can't stand together. That is known as unlawful assembly. So similarly, section 300 of the IPC deals with murder. 302 talks about the punishment of murder and so on. అంటే ఇక్కడ మనం ఏం చూసినాం, ఈవెన్ సోషల్ ఒఫెన్సెస్ అంటే రిలేటెడ్ టు ద పబ్లిక్ ఈక్విటీ, ఎలక్షన్ రిలేటెడ్, పబ్లిక్ జస్టిస్ రిలేటెడ్ కూడా ఇంక్లూడ్ అయి ఉన్నాయి. దాని ఎగ్జాంపుల్ ఏమో సెక్షన్ 141 వెర్ ఇట్ డిస్క్రైబ్స్ వాట్ ఇట్ ఇస్, సెక్షన్ 143 టాక్స్ అబౌట్ ద పనిష్మెంట్. అదే కమింగ్ టు ద క్రిమినల్ సైడ్, 300 టాక్స్ అబౌట్ మర్డర్, 302 టాక్స్ అబౌట్ పనిష్మెంట్ ఫర్ మర్డర్. అంటే దీంట్లో మనం డెఫినేషన్ కూడా ఉంటుంది, ఇంకా పనిష్మెంట్ కూడా ఉంటుంది. సో దిస్ ఇస్ ద వే దాట్ మోస్ట్ ఆఫ్ ద ఐపీసీ is organized. First, a definition of offense is provided, and next the punishment for that offense is stipulated. అంటే ముందు మనం ఐపీసీలో ఆ offense ది డెఫినేషన్ ఇస్తాము, దాన్ని ఇంటర్ప్రిటేషన్ ఇస్తాం, దాని తర్వాత దానికి ఏమి పనిష్మెంట్ ఇవ్వగలరు జడ్జ్ అని అది కూడా కోట్ చేస్తాం. సో పనిష్మెంట్స్ ఆర్ ఆల్సో మెన్షన్డ్. సో హియర్ ఐపీసీలో మనం అంటే మేజర్ యాక్ట్స్లో ఐపీసీ వస్తుంది, సిఆర్పిసి వస్తుంది, ఎవిడెన్స్ వస్తుంది. ఇది మన సబ్స్టెంటివ్ క్రిమినల్ లా. కమింగ్ టు మేజర్ అయితే అయిపోయింది. మైనర్ క్రిమినల్ లాస్ ఏంటంటే ఆర్మ్స్ యాక్ట్ ఉంది, నార్కోటిక్ యాక్ట్ ఉంది, గ్యామ్లిక్ యాక్ట్ ఉంది, ఎక్సైజ్ యాక్ట్ ఉంది, ప్రొహిబిషన్ యాక్ట్ ఉంది, ఎక్స్ప్లోజివ్ సబ్స్టాన్స్ యాక్ట్ ఉంది, ఎక్సెట్రా. సో హియర్ మనం ఏమంటున్నాము, క్రైమ్ అవ్వాలంటే ఇంపార్టెంట్ ఏంది? సో మోస్ట్ ఇంపార్టెంట్ ఫ్యాక్టర్స్ టు కమిట్ అ క్రైమ్ ఇస్ వాట్? A mental factor is the most important. So here we are saying that for a crime, the mental intention is also important. The mental factor is the important thing in saying that this particular act is crime. So whenever a person accused for committing a crime is brought before the court, first of all, his mental condition is studied, whether he's lunatic, whether he's mad. First thing we'll check that. Then after carefully checking whether he's lunatic or how his mental condition is, then whether he was or she was aware of the fact that act committed by him or her was wrongful. Then second step what we do is we'll check whether she or he knows that the thing what he did was wrong. Then a person of unsound mind or intoxicated person is considered to have been done the wrongful act without any guilty intention and hence may not be punishable. So what we are saying, when we get to know that okay, this person was of unsound mind, that is he's mad or else he's drunk. And again, intoxication doesn't mean that you yourself had drinks and all and then you did that. It should be forceful intoxication done by someone else. So when you know that the person is of unsound mind or else intoxicated, then we'll say that that person doesn't have any guilty intention. In a sense, he doesn't have any mens rea, and then that particular thing will not be punishable. In criminal law, there are numbers of defenses available to the accused. The accused will have defenses. So here these defenses are listed below as insanity, mental disorder. So the first point, what they say is insanity and mental disorder, where we say if this is the most common defense, where if someone have committed any crime, they say that no, this person was uh, uh, insane at the time when he have committed the crime, so he doesn't have menstruation, so it's not a offense, something like that. So this is the most common defense used by the accused at large to neglect the crime effect. Here, the accused is declared to be suffering from a mental disorder and is not able to take any sensible decision, as the accused cannot make a difference between the right and wrong. So here mostly what happens is they use this defense, that mental disorder and sanity everywhere, where they cite that the accused was insane, and they say that he doesn't have any mensria, so he escapes the thing, escapes the punishment, because they say that he doesn't have mensria, he doesn't have the thought or thinking to differentiate whether what he did was right or wrong. Coming to intoxication, intoxication ante indi, when you are drunk or when you did some kind of drugs or something like that. So intoxication is a state where a person is intoxicated with some drugs or chemical, etc., and the intoxicated person loses his control on the mental capacity. So once you're drunk or once you're high, you lose all your mental capabilities, where you can think or differentiate what is right or wrong. So thus the focus of defense of intoxication aim is to declare that the accused doesn't have any menstruation. అంటే ఏమంటాం, ఆయన ఇంటాక్సికేటెడ్ ఉన్నాడు, హీ కాంట్ థింక్, అందుకు ఆయన దాంట్లో మెన్స్ట్రీ అనేది ఏముండదు. మెన్స్ట్రీ అంటే తెలుసు కదా, గిల్టీ ఇంటెన్షన్, తప్పు ఇంటెన్షన్. సో మనం ఇంటాక్సికేటెడ్ ఉంటే మనకు ఆ తప్పు ఇంటెన్షన్ రాదని దీస్ పీపుల్ ఆర్ సేయింగ్. So which means that the mental state of an accused was not guilty for the actus rea. So ఏమంటే ముట్టి actus rea అనే ఉంది, mens rea లేదు. So, for example, M claimed that defense for a crime because of drugs overdose, and since he have took some drugs, drugs can also be some medicines. So, he have overdosed on drugs and he have committed a crime. He can take a defense from. Now, coming to other defenses, one is mistake of fact. So, mistake of fact is a genuine and it is accepted by the law. It is accepted by the law. So here, mistake of fact is considered as a genuine and accepted reason by the law. So here, it is another kind of most commonly used defense, where the accused in criminal law says that I made a mistake. అంటే ఏంది మిస్టేక్ ఆఫ్ ఫ్యాక్ట్ అంటే నా 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 తప్పు, నాకు ఇది తెలియదు, నేను అందుకే ఈ పర్టికులర్ యాక్ట్ చేశానని అని డిఫెన్స్ తీసుకుంటారు వాళ్ళు. ఇది కూడా మోస్ట్ కామన్ డిఫెన్స్ అక్యూజ్ యూజ్ చేస్తారు ఇన్ కంజంక్షన్ విత్ అనదర్ డిఫెన్సెస్. అంటే వేరే డిఫెన్సెస్ సహా ఈ డిఫెన్స్ కూడా దే యూస్. ఎగ్జాంపుల్, a charge of assault on a police officer may be neglected by genuine, perhaps reasonable mistake of fact that the person the defendant assaulted was a criminal and not an officer. So here, for an example, what we say that uh, there was an charges on a police officer that he have assaulted another officer, and here he is giving a reason that I was mistaken thinking that person is criminal and he was not an officer. So here the defense is, అంటే ఎగ్జాంపుల్ ఏంది, ఒక మనిషి పోలీస్ ఆఫీసర్ ని అసాల్ట్ అంటే కొట్టారు, ఏమనుకొని ఆయన క్రిమినల్ అనుకొని కొట్టామని వీళ్ళు ఎక్స్క్యూజ్ ఇస్తున్నారు. మైట్ బి దే హ్యావ్ వాంటెడ్లీ did the assault, but they stated the reason that they thought police officer is a criminal and not an officer, so that's the reason they did that assault. So this is a defense of mistake of fact. అంటే మీరు ఫ్యాక్ట్ ని తప్పుగా అనుకున్నారు, తప్పుగా you assumed it is a wrong. Coming to other defenses, necessity or lesser harm. So it means that when a criminal act is justified by the highlighting that it was done to prevent much more harm that could have been done and faced. అంటే ఏమంటున్నాం, వేరే హామ్ ని అవ్వకుండా ప్రొటెక్ట్ చేయడానికి మనం ఈ హామ్ చేసాం. అంటే ఫర్ ఎగ్జాంపుల్ ఇక్కడ ఎగ్జాంపుల్ ఇచ్చారు that example, X claims that Y was critically injured by X, and as Y, a trespasser intended to put a fire on the property of X. So, here's see, what is the thing is X is assaulting Y. So Y was a trespasser, and he was trying to fire the properties X. అంటే Y ఏమో X ప్రాపర్టీలో వచ్చి he was doing what he was destroying Y X ప్రాపర్టీ. Y వచ్చి X ప్రాపర్టీని డిస్ట్రాయ్ చేస్తుంటే X వచ్చి ఆయనని కొట్టిండు ఆర్ ఎల్స్ వాట్ ఎవర్ ఇట్ ఇస్ అసాల్టెడ్. సో ఆ అసాల్ట్ చేసేటప్పుడు Y ఏమో ఇంజ్యూర్డ్ అయిపోయింది. సో ఈ ఇంజ్యూర్డ్ అవ్వడం ఇస్ ఇట్ a crime? Okay, it is a crime, it is an offense, but it is less injurious than what Y was doing. Y was trying to fire the whole property of X. అంటే Y వచ్చి ఎక్స్ ల్యాండ్లో వచ్చి ఎక్స్ మొత్తం ప్రాపర్టీ కాలబెట్టేద్దాం అని అనుకున్నాడు. ఎక్స్ వచ్చి ఆయనను కొట్టిండు. ఆ కొట్టడం వల్ల కొన్ని ఇంజురీస్ అయినాయి. అయితే ఆ ఇంజురీస్ ఆర్ లెస్ హార్మ్ఫుల్ బికాస్ హీ వాజ్ సేవింగ్ హిస్ ప్రాపర్టీ. Lawful capacity of office and legal duty. So this defense is primarily used by the public servant to justify their act as covered and empowered by the authority. అంటే వాళ్ళు ఏమంటారు, వాళ్ళు ఏదైనా తప్పు చేస్తే ఏమంటారు, ఇది మా డ్యూటీ, బికాస్ ఆఫ్ అవర్ డ్యూటీ వి డిడ్ దట్. అంటే ఒక్కొక్కసారి వాట్ దే డూ, దే జస్ట్ క్యాచ్ ఫ్యూ ఇన్నోసెంట్ పీపుల్. పోలీస్ ఆఫీసర్ కొందరు ఇన్నోసెంట్ని వాళ్ళ రివెంజ్ తీసుకుందామని పోలీస్ స్టేషన్కి తీసుకెళ్ళి కొడతారు కదా, might be. So they'll say that I know we thought this person is criminal and we wanted to get some information. And well, chapter this is justified as this is my duty and antaru. For example, ఇంకొకటి ఉంది, a paramedic who was forcefully enter a house or building in answer to an emergency call cannot be charged with breaking and entering. అంటే పారామెడిక్ అంటే మన ఇప్పుడు ఫైర్ ఫైటర్స్ ఉంటారు కదా, వీళ్ళు మనకి ఫైర్ యాక్సిడెంట్ అయ్యేటప్పుడు వస్తారు. అయితే వాళ్ళు మన ఇంట్లో ఎట్లా వస్తారు, బై ladder or somewhere they come. So when they come at, we don't say they're trespassing because we are the one who were asking for their help. So this is not wrong, this is lawful capacity and they are just discharging their duties. Coming to self-defense. Self-defense in the, if someone is attacking on you, you have every right to safeguard yourself and you have every right to harm the opposite person with the equal force. అంటే ఇప్పుడు చూడండి, ఏ వచ్చి బీని ఒక స్లాప్ కొట్టినట్టే బీ హ్యాస్ ఎవ్రీ రైట్ టు స్లాప్ ఏ బ్యాక్. బట్ ఏ స్లాప్ కొట్టినని బీ వెళ్ళి ఆయనని షూట్ చేసేయడం ఇస్ నాట్ సెల్ఫ్ డిఫెన్స్. So let's see the text. It is an act where a person takes a course of action, and while in a course of that, the action defendant is injured. The accused may use the defense of self-defense in this case. So ఇక్కడ ఒక పర్సన్ వచ్చి ఒక యాక్షన్ చేస్తే దానికి రెస్పాన్స్ గా ఇంకొక పర్సన్ కూడా ఆయన ఇంజర్డ్ చేసిండు. అండ్ నెక్స్ట్ పర్సన్ ఇంజర్డ్ చేసి ఆయన ఏమనొచ్చు, ఐ యూజ్ ఇట్ ఫర్ మై సెల్ఫ్ డిఫెన్స్. ఎందుకంటే ఏ వచ్చి ముందు నా మీద అటాక్ చేసాడు, దానికి నేను రియాక్షన్ లో కొట్టాను అని చెప్పొచ్చు. For example, X claims that Y intended to kill him. As defense, Y claims that in course of action of self-defense, he have injured that person. Ante X వచ్చి X claim చేస్తుంది, Y came and tried to kill him. As defense claim, Y claims that the course of action it wasn't self-defense. Y claims that X is a burglar and forcefully barged into the house and to protect its property, Y attacked X and X lost one of his limb. So అదే X వచ్చిండు థెఫ్ట్ కోసం, అయితే వై ఏమో అటాక్ చేసిండు. అటాక్ చేసేటప్పుడు ఎక్స్ ది ఒక చెయ్యో కాలో హీ లాస్ దట్ లిమ్స్, అంటే చెయ్యి కాలు కదా, చేతులు కాలు, వన్ ఆఫ్ దట్ హీ లాస్ట్. సో హియర్ హీ కెన్ సే దట్ హీ డిడ్ ఇట్ ఫర్ సెల్ఫ్ డిఫెన్స్ టు సేవ్ హిస్ ప్రాపర్టీ. సెల్ఫ్ డిఫెన్స్ లో ఒట్టి మనిషి రాదు కానీ ప్రాపర్టీ కూడా వస్తుంది. Let's see here. We can see a list of defenses which are prescribed under Chapter 4 of IPC and can be characterized from Section 76 to 106 of IPC. So first one is judicial acts. Any act done by judiciary is defense. So here it is exempted. So the section starts from 77 and 78. Mistake of fact is from 76 to 79. Accident is from 80 and absence of criminal intention అంటే మెన్స్రియా లేదని ఇంటెన్షన్ లేదని ఇస్తాం కదా డిఫెన్స్, దట్ ఇస్ 81 to 86, 92 to 94. Consent the 87 to 91. What is consent? That the opposite person have given the consent that I can do this particular act, and while doing this particular act if something else goes wrong then he will not be liable. So it is 87 to 91. Trifling acts is section 95. Private defense law you can see is 96 to 106. So what are these private defenses? Act of a person bound by law to do certain things. In essence, his he's just extending his duties. Act of judge acting in judicially. So he's a judge and he's in court. His just fulfilling his obligations. Act done pursuant to an order or a judgment of a court. So court gave an order and you're just executing that offer or that order. Act of a person justified or believing himself justified by the law. If anything is justified by the law and you are doing it, it will be exempted. Act caused by accident. If something happens by accident, even then it is considered. Then again, we have as act likely to cause harm that without a criminal intent to prevent other harm. So here you are doing some act which is to prevent or save someone from some harm. So here it is A and B. B is drowning. A went in. He have steal someone's boat, and then he went near B and get back B out. So here the harm caused was very less because he stole that boat for what cause? To save someone. So here there is no criminal intention. Then again, act of a child under 7 years old. So if any child younger than 7 does something, it is not considered to be a crime. Act of a child above 7 years and under 12 years, but immature understanding. So here, if there's a child who is of less than 12 years and more than 7 years, still will consider that child as child if he doesn't have that maturity, if he's immature. Then act of a person who is unsound mind. So when any person who's unsound mind does that, it is accepted. Act of an intoxicated person is also exempted partially. In a sense, it is partially exempted. How? If that intoxication is done by you yourself, then there is it is not any difference. But whereas coming to the intoxication, it's done by someone else, and it is what forceful, then it is exempted. Act known to be likely to cause death or grievous hurt done by a consent of the sufferer. So consent of a sufferer is the sufferer himself is saying you do this so and so so thing, and she gives the consent. So at that time, if something happens, something grievous happens, by operations they take a signature saying that if something happens, we are not responsible. So the person who is signing that thing, he'll be the person who is giving consent, and even sufferer wants it to be given. So here there is no criminal intention. Act not intended to cause death done by consent of sufferer. So here the same thing, we are signing the signatures done by the person, and here he doesn't have any criminal intention, and even the person that is patient sufferer is also giving their consent, and there is no intention to kill the person that is sufferer or patient. Act done in good faith for a benefit of child or an insane person or by the consent of the guardian. So you did something in the favor of guardian, in the favor of child or else a person who is insane, who doesn't have the common sense. So this consent of guardian can be considered, and it will not be treated as a crime of kidnapping and all stuff. So act done in good faith for benefit of a person without consent. So if first for someone's good you did a act and there is no consent given by their guardian, their parents, or that person himself, still it will not be treated as harm or crime. Communication made in good faith to a person for his benefit. So you made a communication, and that communication was in good faith, and it was for the that person for the profit regarding business or something like that. You're talking, and you have exceeded the some criteria or some law. So here we'll not be treating you as an offender because it is done in good faith. That communication is done in good faith. Act done under the threat of death. So you did some act and you were under coercion. They were threatening you that they'll kill you. So even that is not considered as crime. Act causing slight harm. If there's really minor issue, then it is not a crime. Act done in a private defense. So to save yourself, what you did, you have used the force. That is known as private defense. And the act done in private defense innocence, then we'll be having this private defense ka section where here the person doing certain thing by law, judge acting under judiciary, you're following the order of court, or else you're doing something which is justified by the law, you're causing accident. This is our secondary, this is our private defenses in a sense, something which is done by a single person. So now coming to major offences and their punishment under IPC. So section 120B talks about conspiracy, criminal conspiracy, which is committed by a people like two or more, and it is an offensible punishment. The punishment can be death, imprisonment for life, that too it's rigorous imprisonment. In essence, you should be working, and for a term, the term can be 2 years or upward. 304B talks about dowry death, where we say that if the person, in essence, that wife dies before 7 years. So dowry death లో మనకి minimum 7 years imprisonment ఉంటది, but which may extend to the life term imprisonment. సెక్షన్ 302 లో మనకి ఏంది మర్డర్ గురించి ఇచ్చారు, దాంట్లో మనకి డెత్ ఆర్ ఇంప్రిజన్మెంట్ ఫర్ లైఫ్ అండ్ ఫైన్. డెత్ అయినా ఉండొచ్చు, ఇంప్రిజన్మెంట్ ఫర్ లైఫ్ అయినా ఉండొచ్చు, కానీ ఫైన్ ఇస్ కంపల్సరీ. 307 is talking about attempt to murder. When it comes to attempt to murder, the imprisonment will be for 10 years and it will be fine. Section 308 is talking about attempt to commit suicide. So it is simple imprisonment, that it is only for 1 year, not more than that. So here kidnapping, section 3363 talks about kidnapping and the imprisonment is for 7 years and fine. Theft is 379 and imprisonment is of for 3 years and fine both. Now coming to the criminal procedure code, CRPC is dealing with the procedures to be followed by the inflict punishment upon wrongdoers, which includes the procedure for relating to investigation, inquiry, trial, finally the judgments. So CRPC is like a procedural law where we use this particular process or steps to make sure that the person who have committed crime should get punished. So here, what procedures regarding to the investigation, inquiry, trial, fine, and even the judgment is provided in CRPC. If the accused is found guilty, then he or she will be punished, and if he is guilty could not be proven, but beyond a reasonable doubt, he shall will be let free. If he is guilty, he'll be punishable. If he is not found to be guilty out of the reasonable doubt, he'll be let free or he'll be free. Subject of CRPC is to provide a mechanism for the investigation and trial of offenders. So CRPC is all about how investigation should be taken place, how the trials of offenders are to be taken place, is written in CRPC. It lays down the rules for conduct of investigation into offences by the police proceedings in court against any person who has committed a crime that is an offense under the criminal law. So here we are saying that CRPC is just not a mechanism or rule book for the trial and all. It also makes rules for the conduct of investigation, that how investigation should be done and how the police proceedings should take place in the court. Now coming to the basic terminologies, like what is FIR? FIR is an first information report. What is arrest? The term arrest means an individual that indicates that he is deprived of his personal liberty. In a sense, he'll be in one jail only, na? So then they can say that he is deprived of the personal liberty, and he is also available during the trial of any offense to which such person is associated. So we'll take him to court when he has date of his case. Then bail. What is bail? Bail is like the temporary release. So bail means a procedure where the person that is accused is released from the legal custody by undertaking that he shall be appearing time to time and the place designated, and he'll be submitting himself to the jurisdiction and judgment of the court. So if he is in India, he should follow the Indian laws and he should even listen to the Indian courts. But if they are going out, it is not applicable. Then anticipatory bail is something where, in the cases of non-bailable offences, in a sense, in cases where you don't get the bail, what you're applying for, you're applying anticipatory bail. In a sense, before the person have filed case against you itself, you are applying for anticipatory bail, saying so and so person did like this with me, and there are chances that he might file a case. So at that time, anticipatory bail is useful. So Section 438 of CRPC empowers the High Court and the Court of Session to grant an anticipatory bail, that a direction to release a person on bail issued even before the person is arrested, even one before the punishment In essence, he is arrested, he can claim anticipatory bail and he can move along free. What about charge? A charge is a formulation of specified accusation made against a person who is entitled to know its nature and earliest stage, that is section B of CRPC. According to section B of CRPC, charges include any head of charge where the charge contains more than heads than one. So here it's just thing where what we say charge in a sense one offense, charges in a sense where we have one charge and subhead we have others. So here the charge in a sense where we are just making noting down all the offenses you have made. In essence, you have committed whatever offenses you have committed, we note it together, and that is known as formulation of a charges. Now coming to other, coming to other terminologies, one is trial. What do you mean by trial? Trial is a process where trying the accused to bring the crime to the logical conclusion, resulting into conviction or acquittal. Here, trial is something where in end you know that person is acquitted or convicted. Conviction is where the award of punishment is given or penalty is imposed to the accused. What you mean? What you mean by acquittal? Acquittal is setting free the person, saying that the whatever charges you have applied, it's not satisfied, and there is a benefit of doubt on that person. So whenever there is a benefit of doubt for so and so person, then that person is set free. Difference between bailable and non-bailable, I said in bailable offences there are less chances to get the bail, that is right to bail is denied, but in non-bailable offences it is where court will decide that whether the bail should be given or not. So bailable offences are very less serious in nature, whereas non-bailable offences are very grave and very serious. Difference between cognizable and non-cognizable is cognizable offences are often where the police officer can arrest you without any warrant, without any arrest warrant, they can arrest you. Whereas in non-cognizable offences, police has no authority to arrest an offender without any warrant from the court. So here, what's the difference between compoundable and non-compoundable offences? So a compoundable offence is an offences which is punishable with imprisonment of 2 years or less than 2 years. So here under section 320 we are saying compoundable offence is something where you're punished for less than 2 years or for 2 years. Whereas offences other than those mentioned in 320 are non-compoundable. A promise can be made in the case of compoundable offences, but in case of non-compoundable offences, the parties cannot be allowed to strike a compromise. So in compoundable cases, you have an opportunity to do a compromise, but in non-compoundable cases, there is no opportunity to do any kind of compromises. Coming to the Indian Evidence Act, the Indian Evidence Act prescribes the various evidences to be taken in consideration while dealing with the case. Whenever you're dealing with case, how you need to interpret the evidences, how you need to get the evidences, all written in Indian Evidence Act, whether it is civil or whether it is criminal. Where there are three main rules of Evidence Act, that is, evidence must be confined to the facts in issue. In a sense, it should be related to facts in issue. Only relevant facts are to be considered and admitted. Even if you're giving an evidence, they'll only see the relevant 3 4 lines. See, you give them 1,000 papers, but there is only one 4 line paragraph is relevant, then they'll only check that particular paragraph. Only relevant facts are admitted. Hearsay evidence is no evidence, and such it is generally not admitted. So you can't say that so and so one of my friend was saying about this, so please consider it as evidence. So this, that is hearsay, is not an evidence. The Evidence Act stipulates how facts can be proved through the evidence. The Evidence Act is saying how you can prove facts that to basis on evidence. So here the rules regarding to evidence is laid down under Indian Evidence Act, and the function of the law of evidence is to lay down rules which the facts of case can be proved or disproved in the court. So here when we are filing court, we'll file it with a positive motivation, but later on we can't say whether it will be proved as an evidence or not. The Evidence Act laid down the rules of evidence for purpose of the guidance of court. The Evidence Act helps the judges to separate the wheat from chaff. So gehu and kachra, you do that differentiation. That it is like that. In because of Evidence Act, it is so helpful for the judges and plays a crucial role in establishment of facts during the court proceedings. So whenever you're arguing, you'll be referring to Indian Evidence Act. Then what evidence can be admitted, how it can be admitted, how the burden of proof has to be discharged, etc. All these things are written in Indian Evidence Act. And evidence must be clear, confined to your problem. So what problem? Someone have hit you. If you have that evidences, you can get only something relevant to that. You can't say that I bought my registration number of my particular car or whatever it is, because it's not relevant to question of fact. Here the main principle which form this foundation of Indian Evidence Act is that evidence must be confined to the matter at hand and not hearsay, and best evidence must be given in all the cases. Once of the main objective of evidence law is that uh, it is to prevent the inaccuracy and admissibility of evidence. In essence, you need to avoid the inadequacy or inaccuracy. And here you need to improve more correct and uniform practice rule. In essence, for every court, if there are different rules, you need to form it as a uniform practice rule, and all the evidence should be accurate and adequate. So here, so we have completed the remaining provisions of criminal laws as well. So if you want to see a more paid MCQs, or you want to get the paid mock, you can download the Krishna's Lawrials app. We have the link in description. You can download. You can even follow us in Krishna's Lawrials. You can be connected with us in Telegram as well as WhatsApp. So here we have a what you say group in Let's Crack TS and AP Laws at 2025, both in Telegram and WhatsApp. You can approach us there.